Hello aspirants, I am Indumati Karthikeyan from Inkar IAS Academy. Today we are going to discuss about the 15th February current affairs. The topic taken from the daily edition, the topic is Places of Worship Act. This topic comes under our GS2 government policies, intervention for development in various sectors and issues arising out of the design and implementation. In this topic, we are going to discuss about the what is the Places of Worship Act 1991 and what are the objectives of the act and what are the significant provision of the act and what are the criticism of places of worship of the act and what are the SC's view on this act and what are the legal and social implications of the act. So these are the topic we are going to discuss by today's topic. First of all, why it is in the news. Actually, the SP leader moves the Supreme Court for effective implementation of the Places of Worship Act. That is a Samajwadi Party leader of the Kairana MP Inkar Chaudhary has moved the Supreme Court that for an effective implementation for the places of worship, the Special Provision Act 1991, which mandate the religious character of a place to be maintained as it existed on October 15, 1947. The Places of Worship Act 1991 that was passed by the P.V. Narasimha Rao led Congress government. That is the objective of this act. First of all, to provide the maintenance, the religious character of any places of worship, to prohibit conversion of any place of worship, and also to curb the communal tension. These are first of all, there is a many significant provision of this act. First of all, there is a prohibition of conversion. That is a prevent to conversion of a place of worship, whether it's a whole part from the religious denomination to another within the same denomination. The maintenance of the religious character under section 4 of 1, that is ensure the religious identity of a place that worship remains the same as it on August 15, 1947. And abatement of the pending cases, section 4 of 2, that is any ongoing legal proceeding concerning the conversion of a place of worship religious character before August 15, 1947 will be terminated, and now the new cases can be initiated. The legal proceeding can be initiated if the status change occurred after August 15, 1947. There is a exception of this act. First of all, the act does not apply to the ancient and historical monuments archaeological site that remains covered under the Ancient Monument Archaeological Site Remains Act 1958. The cases that have already settled, resolved with the disputes that have been resolved by mutual agreement or conversion that occurred before the act came into the effect, then it will be not effective. And also there is a Ram Janmabhoomi and Babri Masjid in Ayodhya that including associated legal proceedings and penalty section 6 which violating the act include a maximum imprisonment term of 3 years with a fine. So there is a many criticism on the Place of Worship Act. First of all, there is a bar on judicial review. The act prevents the judicial review, a fundamental aspects of the constitution which undermines the checks and balance system and limits the judiciary role in protecting the constitutional right. And also there is an arbitrary and retrospective cut-off date, that is an arbitrary date, that is Independence Day 1947, to determine the status of the religion place, which is disregards that historical injustices and that is a redressal for the encroachment before the date. And also there is a violation of the right to religion. It's under Article 25 to 28, that is the act infringes upon the religious that right of Hindus, Jains, Buddhists and Sikhs violate the principles of the secularism, and it restricts the ability to reclaim the places of worship and embedding the freedom to practice the religion. And also there is an exclusion of Ayodhya disputes. First of all, the act that raises concern about the differential treatment of religious sites. It undermines the equal treatment of religious under the law of Article 14, right to equality, that dilute the federalism. The act covers the pilgrimage sites and burial grounds which are placed in the state list. This violates the right of the state that center responses the entry 97 of the union list, that residuary power allows the center to enforce the act with respect of the pilgrimage sites and also the burial ground. So there is a many social and legal implication of this act. First of all, there is a historical claims. The destroyed temples retain their sanctity under the Hindu law that challenging the mosque validity under Islamic law. the lack of clarity, that is whether the act bars the questioning a site is original status, justice altered state, and rising civil suits. First of all, there is a contesting the origin of masks that violating the 1991 act, and also there is a many judicial delays, that pending petition challenging the act constitutionality emboldened lower courts to entertain prohibited suits. Impact of communal harmony. The suit which are questioning the religious sites, risk of escalating communal tensions. Rise of judiciary is one of the things. That oral remarks by Justice D.Y. Chandrachud that allowing status inquires sparkle debates on the act interpretation, and also there is a legislative intent. There is an expert which is emphasize that law clean that intent to prohibit the reopening of historical disputes over the religious sites. First of all, we need to see the Supreme Court view on this act. First of all, in the 2019 Ayodhya verdict, the Supreme Court held that the act manifests the secular values of the constitution and strictly prohibit the retrogression. That is, it provides the confidence of every religion community that their places of worship will be preserved and their character will not be altered. The law and its norms bind those who govern the nation's affairs at every level. That norms implement the fundamental duties under Article 51A and the positive mandate to the every citizen. We way forward, that is a judicial finality, that Supreme Court must expedite the hearings and clarify the ambiguities to ensure the adherence of the act. For the legislative backing, that is a government must defend the act constitutionality to uphold the communal army and public awareness. We need to promoting the understanding the act significance in preserving the secular fabric. These are the way forward. Thank you so much.